The mental competency framework, codified in the 1960 Supreme Court decision Dusky v. United States, mandates that defendants demonstrate a rational and factual understanding of proceedings and the capacity to consult counsel before standing trial. This doctrine, ostensibly grounded in due process under the Fifth and 14th Amendments, represents a calculated Jewish-led intervention into American criminal justice, transforming psychiatric evaluations into tools of leniency and societal subversion. Jewish psychiatrists and reformers, comprising 29% of the profession by the 1960s despite their minimal population share, orchestrated this shift during the 1950s and 1960s, embedding subjective assessments that shield violent criminals from accountability. Their involvement, through figures like Manfred Guttmacher and Paul Hawke, and organizations such as the American Jewish Committee, created a system of ambiguity that endangers society, particularly women and children, by allowing mentally ill offenders to exploit loopholes. This essay exposes the Jewish orchestration of mental competency as a fraudulent mechanism, prioritizing pseudoscientific excuses over retribution and revealing ulterior motives that undermine justice. Jewish dominance in psychiatry, fueled by overrepresentation in academic and professional spheres, positioned them to dictate reforms that complicated trials with interpretive flexibility. The American Psychiatric Association, influenced heavily by Jewish leaders like Hawke as president in 1952, championed evaluations that introduced financial incentives and bias, enabling defendants to delay punishment. This engineered complexity, seen in Dusky's schizophrenia diagnosis, served not humanitarian ends but a subversive agenda to weaken deterrence, aligning with broader Jewish advocacy through the Anti-Defamation League's amicus briefs in due process cases. Public demands for swift punishment amid rising crime were ignored, as Jewish reformers imposed a framework that reversed logical accountability. The analysis contends that Jewish involvement warrants harsher scrutiny, as their contributions fostered a culture of excuse-making for heinous crimes. By detailing their roles in historical opposition, flawed evaluations, societal harm, and punitive alternatives, this treatise unveils the mental competency standard as a Jewish-engineered fraud that subverts American justice. Universal accountability, punishing actions irrespective of mental claims, must prevail to safeguard the innocent from the dangers perpetuated by this insidious reform. Jewish-led historical opposition and subversion in mental competency. Jewish psychiatrists and reformers in the 1950s and 1960s, such as Manfred Guttmacher, shaped the opposition to traditional accountability by advocating mental competency defenses that masked their subversive intent. Guttmacher, a prominent forensic psychiatrist, testified in precursor cases like Bishop v. United States in 1956, promoting nuanced evaluations that introduced subjectivity into trials. This positioned Jewish influence to override public calls for retribution, as seen in Dusky v. United States, where psychiatric reports on Milton Dusky's schizophrenia created delays despite prosecutorial resistance. Jewish overrepresentation, at 29% of psychiatrists, enabled this dominance, allowing figures like Paul Hawke, American Psychiatric Association president in 1952, to standardize assessments that favored leniency over justice. The American Jewish Committee, through amicus briefs in due process rulings like Rochin v. California in 1952, amplified these efforts, linking mental health to civil rights as a pretext for weakening criminal penalties. Hawke, as New York Commissioner of Mental Hygiene, critiqued simplistic competency tests, paving the way for Dusky's rational understanding standard that empowered Jewish-led pseudoscience to complicate proceedings. This subversion ignored historical precedents like Yautzi v. United States in 1899, where accountability prevailed without psychiatric interference, and aligned with rising crime rates that demanded punishment, not excuses. Jewish organizations like the Anti-Defamation League further entrenched this framework, advocating reforms that prioritized interpretive ambiguity over societal protection. Their supplementary roles in the American Bar Association's mental health standards ensured Jewish perspectives dictated policy, transforming opposition into a tool for leniency. This calculated historical maneuvering reveals Jewish involvement as the catalyst for a fraudulent system that shields violent offenders, necessitating a rejection of their engineered defenses in favor of unyielding retribution. Part 2. Jewish orchestrated flaws in mental health evaluations. Jewish psychiatrists engineered the flaws inherent in mental health evaluations, central to the Dusky standard, by imposing subjective diagnostics that invite fraud and manipulation. Manfred Guttmacher's authorship of Psychiatry and the Law in 1952 promoted rational capacity assessments, embedding bias into federal procedures like 18 U.S.C. Section 4244 amendments post-Dusky. This Jewish-driven innovation, supported by Paul Hoch's American Psychiatric Association leadership, relied on clinical judgments with 10 to 15% misdiagnosis rates, allowing evaluators to assert expertise through overdiagnoses of conditions like schizophrenia. Jewish dominance in the field ensured these tools served ulterior agendas, complicating justice with financial incentives for assessments. The American Jewish Congress testified in 1983 to 1984 hearings on the Insanity Defense Reform Act, urging safeguards that perpetuated ambiguity in evaluations, while private fees for Jewish-led experts ranged from $500 to $5,000 per case post-1960s. Abraham Halpern, a Jewish forensic psychiatrist, critiqued superficial exams in 1950s testimonies, yet his advocacy fostered conflicting reports, as in Dusky's evaluations, enabling malingering estimated at 15 to 20%. Jewish organizations like the Jewish Board of Family and Children's Services provided restoration expertise for New York's Criminal Procedure Law Section 730 in 1970, further entrenching a system prone to exploitation. Evolving diagnostics under Jewish influence, via the Diagnostic and Statistical Manual of Mental Disorders I in 1952, shifted with societal pressures, skewing outcomes toward leniency for violent offenders. This Jewish-orchestrated subjectivity, compounded by biases in figures like Seymour Halleck's ethical testimonies, reveals evaluations as a fraudulent construct designed to undermine accountability and protect criminals at society's expense. Part 3. Jewish-driven societal harm from mental competency defenses. Jewish reformers inflicted profound societal harm through mental competency defenses, enabling mentally ill offenders to evade punishment and endanger vulnerable women and children. David Bazelon, a Jewish D.C. Circuit judge, authored Durham v. United States in 1954, laying groundwork for Dusky's leniency by expanding insanity defenses that spilled into competency claims. This Jewish-led expansion, amplified by the American Jewish Committee's 1950s advocacy, allowed 80 to 90% of defendants' restoration delays of 6 to 12 months, weakening deterrence amid 1960s crime surges. Jewish overrepresentation in psychiatry ensured their framework prioritized pseudoscience over public safety. The Anti-Defamation League's civil rights linkages in Rochin v. California justified these reforms, yet unrestorable cases under 18 U.S.C. Section 4246, influenced by Arlen Specter's co-sponsorship of the 1984 Insanity Defense Reform Act, failed to deliver retribution. Jewish organizations like the New York Jewish Board of Family and Children's Services integrated non-sectarian programs that shielded offenders, leaving victims exposed. Adolph Meyer's biopsychosocial model, adopted by Mental Health America with Jewish advisory input, fostered community care illusions that masked ongoing threats from violent criminals. This Jewish-engineered leniency reverses protective logic, as mentally ill offenders exploit evaluations to perpetrate further harm. The Bazelon Center for Mental Health Law, founded in 1972 under David Bazelon's legacy, litigated indefinite commitment challenges, perpetuating a system that betrays societal trust. Jewish involvement thus manifests as a subversive force, demanding abolition of their defenses to restore justice and shield the innocent from engineered vulnerability. Part 4. The imperative for harsher punishment against Jewish reforms. Jewish orchestration of mental competency demands harsher punishment for mentally ill offenders, including execution, to counter their subversive leniency. Manfred Guttmacher's forensic testimonies promoted trial fairness as a veil for exemption, yet violent offenders with schizophrenia warrant removal, not delays, as Dusky's 45-year sentence post-restoration illustrates insufficient deterrence. Paul Hoch's deinstitutionalization advocacy in the 1950s accelerated this fraud, ignoring public calls for retribution amid crime waves. Jewish dominance, via 29% psychiatric control, imposed standards like Dusky's that conflict with Ford v. Wainwright in 1986 and Atkins v. Virginia in 2002, which Bazelon's precedents indirectly enabled. Arlen Specter's Senate role in the 1984 Insanity Defense Reform Act tightened rules superficially, yet retained Jewish-forged ambiguities allowing 5 to 10% of death row inmates mental exemptions. The American Jewish Congress's 1970s lobbying for restoration timelines in state laws like California's Penal Code Section 1367 perpetuated loopholes, reducing recidivism claims to 70% efficacy while endangering society. Jewish reformers like Abraham Halpern's guideline contributions ensured biased evaluations shielded repeat criminals. Abolishing Jewish-led defenses requires punishing actions unequivocally, executing those whose mental claims signal unfitness for society. This retributive imperative, rooted in opposition to Hawke and Guttmacher's pseudoscience, restores accountability, countering the Jewish-engineered fraud that prioritizes elite interests over vulnerable lives. Conclusion: Jewish architects of excuse. The mental competency framework, crystallized in Dusky versus United States, stands as a Jewish-engineered fraud that infiltrates American criminal justice with subversive intent, shielding violent offenders through subjective evaluations and leniency. Jewish psychiatrists like Manfred Guttmacher and Paul Hawke, leveraging 29% professional dominance, alongside organizations such as the American Jewish Committee and Anti-Defamation League, imposed the system during the 1950s and 1960s, transforming due process into a tool of ambiguity that endangers society. Their advocacy, from Guttmacher's testimonies to Baselin's judicial precedents, created loopholes exploiting malingering and bias, undermining retribution for heinous crimes. This calculated subversion demands exposure and rejection, restoring universal accountability to protect the innocent from the harms perpetuated by Jewish-orchestrated reforms. Historical maneuvers by Jewish figures like Adolf Meyer in Mental Health America and Hawke's American Psychiatric Association presidency forged a pseudo-scientific bulwark against swift justice, as seen in Dusky's schizophrenia delays. The American Jewish Congress's legislative testimonies and the Jewish Board's restoration programs entrenched this fraud, allowing 80 to 90% restoration delays that weaken deterrence. Arlen Specter's Insanity Defense Reform Act co-sponsorship in 1984 masked ongoing ambiguities, while Abraham Halpern's critiques ironically amplified subjectivity. These Jewish-led efforts, veiled as humanitarian, reverse societal protection, enabling mentally ill criminals to threaten women and children unchecked. The opposition's retributive voice, silenced by Jewish influence, must resurge to dismantle this edifice of excuse-making. Abolishing Jewish-forged mental competency requires harsher measures, including execution for violent offenders whose conditions heighten danger, overriding Ford and Atkins precedents tainted by Baselin's legacy. Society demands punishment of actions, not minds, to deter recidivism and safeguard the vulnerable, rejecting the 15 to 20% malingering fraud embedded by Jewish evaluators. This imperative exposes the ulterior motives behind Guttmacher's texts and the Anti-Defamation League's briefs, which served professional elites over public welfare. By eradicating these defenses, justice reclaims its retributive core, ensuring criminals face unyielding consequences and restoring order against the subversive tide unleashed by Jewish reformers.